I have a good friend that was going into the grocery store recently in the wintertime after our tremendous snowfall that we had, and when she walked into the store, the floor had not been properly mopped, and obviously or evidently there was a fair amount of water on the floor, and she fell and broke her wrist quite severely, where she had to have pinned.
Mm-hmm.
And what are some of the issues, or what are some of the concerns that one would have on filing a personal injury case?
Along the nature of your friend's story. Well,
Yes.
the issue with premises liability, first you have to show the duty of care. Obviously, a landowner in New York has a duty of care to act reasonably to prevent foreseeable risks of harm on its property. So in the case of a slip and fall on property, you have to establish first it was a dangerous condition. Water inside a supermarket aisle is a dangerous condition. People can slip, people fall. Where the case gets difficult from the plaintiff's point of view is that a landowner is not an absolute insurer for people on its property. Just by the fact you fell doesn't mean that the landlord is responsible or liable to the person. You have to show that there was a dangerous condition, and either the landlord or the landowner or the tenant, the person in control, the entity in control, either they created that condition, they, through their employees, agents, servants, whatever, or they had either actual or constructive notice of the condition. So you take, for example, the wet floor in a grocery store. Mrs. Plaintiff comes along, falls, breaks her wrists. To prove that case, she would have to establish, yes, there was a supermarket that owned the property and they had an obligation to keep the premises safe. Yes, there was a dangerous condition, water or a slippery substance on the floor. The key question in the case would be, is there notice? Is there evidence that the store owner created the condition? Evidence to the effect of a witness saying, the store clerk had dropped something and it spilled a half hour ago and they never cleaned it up. Well, that's very rare that you have evidence like that. If there's no evidence that the store created the condition, then you'd have to establish that they were legally on notice of the condition. Two types of notice: actual notice, which is sometimes you're in the supermarket, you'll hear, we got to clean up on aisle 6. Charlie sent somebody from the back to clean up aisle 6. Actual notice, or constructive notice, where there is evidence from a witness who will say, no, that was there 3 hours ago, or 2 hours ago, whatever it might be, and the law will deem that the property owner has a duty of care to inspect its property periodically and to determine if there are dangerous conditions and remedy them. That might be evidence, perhaps, that the defendant, while maybe not creating the condition or actually knowing, was on constructive notice. They should have known. Particularly the scenario you're giving me, that's a little bit more complicated, where you have an outside condition and people are bringing melted ice, snow into the store. The case law would suggest that you don't have to prove in those situations the particular puddle, let's say, that the client fell on, or the notice thereof, I should say. There's case law that says where there's a recurring condition, whether it's raining outside, you're on notice of a recurring condition of people tracking water in on their shoes. Well, then you have to take reasonable measures to remedy that condition. So in that particular case, I'd be interested to know what measures they had taken. Were there mats out? Were there mats inside the foyer, inside the store, all the way in? Facts to that nature would go, toward the merits of the case.
Frequency of mopping the floor.
That kind of thing.
Okay.
But you'll get very often a client who's seriously injured and they fell on somebody's property and they don't realize that it's not that simple. You've got a couple of parts in the equation there, but you still have to show negligence liability. And very often notice is the critical element of the liability, of finding a liability against a property owner.
So just having a wet sign there may serve its purpose then, or wet floors?
Well, that would go toward a wet floor sign would not necessarily exonerate a landowner from liability, but it would certainly be evidence of its duty to warn, and it could certainly be evidence of a plaintiff's comparative negligence. New York is a comparative negligence state, which means when juries are instructed on the law, they're told that they can apportion fault between a plaintiff and a defendant or between multiple defendants. They're instructed that they can find a mixed verdict. They can find, yes, Mr. Landowner, you were negligent, you should have cleaned up that water, you were on notice of it. But Mrs. Plaintiff, you should have seen that sign, you should have been more careful. So we'll apportion fault 60-40 or 70-30 or 50-50 or something to that effect.
So it's important that the store is mopping that water up, that standing water up on a routine basis.
Yes, yeah, and I'm sure most stores are very, the larger chains are getting advice from their home office and human resources and are going through painstaking classes and processes to make sure their employees are aware of that. But what happens in real life is sometimes other than the case.